Hello friends, welcome to our channel Steno. This dictation is for the aspirants who are preparing for the Bombay High Court exam. The basic facts which are not in dispute before this court is that the appellant came to be selected for the post of stenotypist in Hindi in PWD following a regular process of selection in pursuance of an advertisement. Under the terms of the advertisement, candidates were required to possess a minimum typing speed of 80 words per minute in taking Hindi shorthand and 25 words per minute in Hindi typing. The appellant qualified in the selection process and was duly appointed. Though the appellant was placed in terms of the office memorandum on a temporary basis, it is not in dispute that the appointment was against a substantive vacancy after a regular process of selection. The complainant sought to question the process of selection by levelling allegations of irregularities against the appointing authority to the Chief Minister. Following this, an inquiry was held by the Additional Commissioner in which the complainant was called upon to participate. Significantly, the appellant whose appointment was being questioned was not associated with the inquiry. Based on the report of the Additional Commissioner, a conclusion was drawn that the appointment was improper, and accordingly, on July 27, 1999, the appointment was cancelled. There is merit in the submission of the appellant that this has not been preceded by a recourse to the principles of natural justice. In the facts of the present case, as we shall indicate hereafter, the method in which the typing speed was to be calculated has itself been a bone of contention, particularly in a situation where the complainant was heard. It was but appropriate and proper that the appellant should have been heard where the consequence of the report of the Additional Commissioner was to visit the appellant with an order of termination. Absent compliance with the basic principles of natural justice, there has been a patent unfairness in the process which has been adopted by the authorities. The disciplinary inquiry, which was concluded against the appointing authority, resulted in an inquiry report dated 18 November 1999 of the chief engineer, which exonerated the appointing authority. In fact, we may note that the evaluator who was examined during the course of the disciplinary inquiry explained the basis on which the typing speed of the appellant had been computed. The appellant has relied upon this aspect of the disciplinary inquiry. The evaluator sought to explain the evaluation of the answer sheet by stating that the typing speed of the appellant has been computed as 31 words per minute, 156 correct words divided by 5 minutes. We are indicating this aspect because, particularly in a situation like this where there is no allegation of fraud against the selected candidates, it is but necessary and proper that a termination of the services post appointment should have been preceded by compliance with at least the basic norms of fairness. The inquiry was held completely behind the back of the appellant, and his services were terminated in consequence.